Hi, welcome to our very first webinar with me, Charlotte Geesin, Head of Employment Law and Business Immigration at Howarths. Just before we start, I just want to check that everybody can hear me. So I think there's a Q&A function on your screens. Would you just be able, a couple of you, to type in yes, no, don't know, just so I can get a bit of a straw poll? Excellent. A few of you replied. Fantastic. Right. On the basis that a few of you can hear me, I'm going to take it that if there are any issues with sound or video, that it's at your end as opposed to mine. My colleague Louise, she's sat in the background for technical support. So if at any time the connection drops or anything like that, if you just type a message in this chat box, we'll be able to pick that up and do our best to resolve it for you. Now that everybody can hear me, again, officially welcome to this webinar, which is going to be a bit of an update in terms of all things furlough. Going to try and run for about half an hour, something like that. Timing's not my strong point though. May run over a couple of minutes, particularly because we've got so much to get through. At the end of the sort of designated half an hour, I'm going to do a bit of a bonus session, which you are more than welcome to stick around for, and just sort of spend maybe 10, 15, 20 minutes, see how we go, talking about Boris's roadmap, which he obviously announced last night, and try and take some live questions from you all in terms of how that might affect your business and what sort of things you need to be thinking about, given that he's effectively said people should be going back to work if it's safe for them to do so. In terms of the question side of things, obviously a few of you have already put forward some questions, which is brilliant. Thank you so much. I have done my very best to build the answers to those questions into this presentation. But obviously, if you have any questions as we go, just ask them live, and I'll do my best to give you a response right here, right now. For those questions that I'm not going to be able to get around to due to timing or volume, don't worry. Following this session, I am going to be preparing a question sheet, maybe I'll think of a better title for it in due course, where all the questions that have been asked today and that are asked today are set out in an anonymous fashion, and whereby I put some advice and responses to those. Those will be made available sort of 24, 48 hours after this session, and for your enjoyment, hopefully. At the end of the session, I'm going to hand over to my colleague Louise, who, like I say, sat in the background, and she's just going to finish off for a couple of minutes. So please wait to see her lovely smiling face before you log off. Final sort of administrative point before we sort of launch into what you've all come here to hear about is that this webinar is being recorded. If you're unhappy with that, then unfortunately there isn't really another option other than for you to log out now. It's GDPR, soz. Right, okay. In terms of the latest government guidance then, obviously we had Boris on screen last night giving us an update in terms of the roadmap for exiting the lockdown, and like I say, we'll discuss that at the end of this session. The sort of key message though for employers was that if individuals can work from home, then they should continue to do so, but if they can't, then they should be actively encouraged to return to work this week. Now, that statement sort of raises more questions than it answers, but we'll do our best to sort of run through any issues that you have at this stage. In terms of the furlough scheme then, and where we're at with that, there haven't actually been any updates for a week or so. The most recent updates that we received referred to employees being able to accompany colleagues during disciplinary, grievance, redundancy meetings whilst on furlough, and also about directors who pay themselves once a year being able to claim furlough pay. We did prep an update on that at the time. Hopefully you saw that pop through on your emails, but if not, there is a record of all the articles that we prepped today on our website. As it stands today, the furlough scheme is still due to end on the 30th of June, and we don't believe that there are going to be any changes to the operation of that scheme from now up until its expiry. However, there is obviously a lot of speculation about what might happen at the end of June. Currently, suggestions that the scheme will be extended are being made, as are suggestions with regards to an industry-specific furlough scheme for hospitality, leisure sectors, and also, and I think this one is probably the most likely to be implemented perhaps, a phasing out, a phasing down of the furlough provision. It's been on the radio this morning that come the 1st of July, the furlough scheme won't automatically be withdrawn. Instead, it will continue to apply, albeit with 60% wage support as opposed to 80%. Whether that actually happens, though, we just don't know. Everything's completely up in the air. Although Rishi Sunak last week made a comment about UK employers being addicted to furlough. I'm not sure how well that went down overall, but either way, maybe that doesn't bode well for an extension to the scheme past the 30th of June. I don't know. We shall see. Obviously, as soon as any more details are issued, we will let you know immediately. First question has popped through. Thank you very much for that. It's about bank holidays and furlough and what happens if people are furloughed on a bank holiday. I'm actually going to be covering that in this next section, so hopefully I'll be able to give you the answer to that. But obviously, if you want some more detail, then just pop some more info into the Q&A box shortly. Okay, so annual leave and furlough, perhaps the most vexed issue that has sort of come to light really when the furlough scheme is considered. Unfortunately, despite our sort of hopes and prayers, there has still been no definitive or updated guidance on the matter of annual leave during furlough since the 1st of May. On the 1st of May, the government updated its employee guidance on furlough, not its employer guidance. That still remains completely silent. And I'll run through with you exactly what that says and sort of talk to you about the implications and the interpretation of those statements. Before I do that, though, I just want to very quickly clarify the existing legal position when it comes to annual leave, because I think it's important for you to have an understanding of the distinction between statutory holiday and contractual holiday, because that is relevant when you're looking at what you can and can't do with annual leave for your employees who are on furlough. So in the UK, it's the Working Time Regulations 1998 that give employees the right to annual leave. The purpose of annual leave is rest from work, and in spite of what your employees might think, it's not a right to jet off to Spain or go to a caravan in the Lake District for a couple of weeks. They can choose what they do with their annual leave, but your primary obligation is to give them some rest from work. The minimum requirement for annual leave under the Working Time Regulations is 5.6 weeks or 28 days. The part-time employees, obviously that's prorated according to the hours that they work. And this 28-day minimum or the pro rata equivalent It applies however somebody is employed, so whether they're casual, 0 hours, bank staff, whether they work the same number of hours a week or a varied number of hours, the fact remains that they are entitled to 5.6 weeks or 28 days annual leave per year. The entitlement calculation, when it comes to the amount of leave and the rate of pay, is different depending on how someone is employed, but the entitlement is the same. Now, this 28-day minimum is the UK statutory entitlement, which differs from the EU statutory entitlement. Now, that's important because when it comes to the government's rollover provisions for annual leave for people on furlough, that only applies to the EU entitlement, which is 20 days. So don't get the two confused. When it comes to bank holidays, most employers in the UK choose to include the UK's 8 bank holidays in the 28-day statutory minimum, thus leaving employees with 8 sort of fixed days holiday, the bank holidays, and 20 days that are more flexible, which they can choose to take whenever they want. The position in respect of bank holidays is usually dictated by an employee's contract. So if you have any sort of doubt about what your employees are entitled to, just check the annual leave provisions in the documentation that you've issued to them to date. In addition to statutory leave, obviously some employers go over and above and give people additional annual leave on top of that 28-day requirement. That additional holiday, whether it's 1 day, 5 days, 10 days, 20 days, is what's known as contractual holiday. And the employer ultimately has a degree of control about what happens with that contractual holiday. And that's an important point for considering what you can and can't do with annual leave during the furlough scheme. Thank you for that question about rollover. Again, I'll come on to this very shortly, but essentially the answer is yes, there is an obligation to roll over if you cannot allow employees to take leave because they've been on furlough, but it's capped at that EU entitlement, the 20 days. In terms of the government's employee guidance then, which is all we have from Boris and his chums about how we're meant to deal with the issue of annual leave and furlough, this is what it actually says. There's 7 or 8 points. The first point is that during furlough leave, an employee's entitlement to annual leave will accrue as per their contract. This means that an employee's entitlement to statutory holiday and contractual holiday will accrue as normal. The guidance says that an employee can agree with their employer to vary their annual leave entitlement during furlough leave, but they cannot vary the 5.6 weeks minimum. Now, this is a really interesting point because basically what it says is that for the purposes of the 28-day minimum, you're stuck, that accrues and there's nothing you can do about it. However, if you offer your employees extra holiday, you can actually seek to try and vary that down or delay it or change the rate of pay maybe for that annual leave for any leave on that basis that falls within the furlough period. Now, without getting in sort of the ins and outs of it, essentially that could be a way to enable you to reduce some of your financial liabilities during the furlough period. It's like I say, an interesting point. The guidance goes on to say that an employee can take holiday whilst on furlough, and any holiday taken must be paid at the employee's normal rate of pay. At the start of April, the calculation period for holiday pay changed. So if you have an employee whose pay or hours of work vary, to calculate holiday pay, you have to go back for the previous 52 weeks of work carried out as opposed to the previous 12 or 13. The calculation point can be quite complicated, especially with casual workers or workers who receive rolled up holiday pay. The manner of calculations unfortunately falls outside the remit of this webinar. And I know a couple of you asked some questions about calculating holiday pay for rolled up holiday pay recipients. And I would suggest that actually you contact me or a member of the team direct on that so that we can help you work through the calculation step by step. The guidance goes on to say that whilst annual leave can be taken during furlough leave, An employer can restrict the taking of that leave where there is a business need. It doesn't go on to say the opposite, which is an employer can force the taking of annual leave during furlough leave where there is a business need. That would have certainly been helpful, but we don't have it at the moment. When it comes to bank holidays, the guidance is hopelessly vague, but what it does say is if an employee usually works the bank holidays, then the employer is able to claim the 80% grant payment for any holiday taken in that regard. Like I said before, holiday must be paid at 100%, so you must top up any holiday that's taken, including bank holidays, but you can claim the 80% portion. If an employee usually takes the bank holiday as leave, which I think is probably, in most cases, then the employer would either have to top up the pay to the usual holiday pay, like I say, or give the employee a day of holiday in lieu. The government's policy in this regard is under review. So if and when this changes, we will let you know straight away. Although that guidance isn't massively helpful, there are a couple of practical points that we can take away from that, I think, which hopefully prove quite useful to you. Like I say, although the guidance allows employees to be on annual leave during furlough, it doesn't say that employers can require employees to take annual leave during furlough. However, there appears to be no problem with an employee requesting leave or parties agreeing leave. And if either of those situations present themselves, then it seems right to me that an employer can make a claim under the CJRS for 80% of any annual leave taken, whilst topping up the remaining balance. So I suppose depending on how good a relationship you have with your employees, or how good you are at sort of getting your car salesman type head on, if you're looking at wanting to get your employees to use up some annual leave entitlement during furlough leave, a conversation with them might not sort of cause you to actually lose anything. If they say no, they say no. But if they say yes, and you can agree a taking of some leave, you will be able to reduce the employee's annual leave entitlement during the furlough period, whilst also claiming 80% of that back from the government. If an employer does force an employee to take annual leave, which obviously at the minute sort of sits outside of the official guidance, then we don't really know what the consequences of this are yet. The government hasn't told us. The biggest issue, I think, will be an unsuccessful grant claim, or some kind of consequence for trying to claim a grant payment for holiday which was forced. However, as far as the risk goes when it comes to an employee challenging any decision, whilst there could be a sort of trust and confidence type argument, if they're paid in full for that leave, then I'm not really sure what else they could do. So whilst my sort of official advice to you has to be, do not allow your employees, or do not force your employees to take annual leave during furlough leave unless they've asked for it or unless they've agreed to it, you may seek to want to take a calculated risk based on business needs, and sort of see how you go with it. Like I say, having a conversation with your employees about the possible taking of leave, I can't see how that could come to any harm. Obviously, each case will turn on its own merits, and each employer's needs will be different. And if you do want to talk about this further, then obviously just drop me an email or a member of the team at any point, and we'll be happy to talk through it. Couple of questions there about bank holidays. Hopefully I'll be able to address those now, but we'll see. When it comes to bank holidays, the definitive position, obviously unclear, like all the rest of the guidance that we've had. Like I say, the government advice says that annual leave can be taken during furlough, and it also says that where an employee takes bank holiday during furlough leave, the holiday must be topped up to 100%. As such, and this is an obvious point, but a relevant one, the guidance clearly allows for bank holidays to be taken during furlough leave. The guidance doesn't provide any automatic right for an employer to force an employee to take these. However, again, if you can get your employees to agree to those days forming part of their annual leave take during furlough leave, then I can't see any problems with you recording those bank holidays as annual leave and you claiming 80% and topping up accordingly. If you can't get your employees' agreement, then again, it has to be the case that unfortunately they remain available for the employees to take later on in the year, and they're just recredited to the employees' overall annual leave allowance to take when they come back to work. So just in terms of the questions that we've got, bank holidays that occur during furlough, do they need to be added as holidays to be taken to their entitlement? Possibly. If you can't get agreement for the employees to take them, yes. If we didn't pay the bank holiday 100% to furloughed employees, what would we need to do in this respect? Well, any holiday has to be topped up to 100%, and there's nothing that you can do about that. If the question's more about if the employees didn't take the bank holidays or you couldn't get them to agree it, then you'd have to roll those bank holidays over and recredit them to the employee's overall allowance. How do we get the agreement? Does it have to be written? Yes, I think that would be a good idea, just in case of a dispute later down the line. However, I have no issues at all with you starting the sort of conversation verbally. That's obviously going to be easier, particularly if you have employees who are off site. And actually, I have no issues with the sort of whole conversation being verbal, as long as there's some written confirmation at the end of that discussion that sort of confirms your position. Can you ask staff to take contractual holidays? Yes, you can ask them to take contractual holidays and statutory holidays. But ultimately, if they don't agree, then the default position is that the individuals are entitled to that holiday when they come back to work. Even though the overall position with holiday is bleak, we can talk about a silver lining of sorts. When it comes to annual leave during furlough. When it comes to the question of annual leave that was pre-booked by an employee before they ended up on furlough, an employer can still require an employee to take that leave during the furlough period. The employer must top the holiday pay up to 100%, but provided that they do this, there's actually no obligation on an employer to allow the employee to cancel any pre-booked leave that falls during the furlough period. Remember, your obligation is to give an employee the opportunity to take annual leave for the purposes of rest from work, and not for them to go to Spain or wherever they want and sort of, you know, in terms of their choice about what they do with that annual leave. You can choose to force them to take that pre-booked leave or to recredit it. It's entirely up to you. When it comes to the holiday rollover provisions, the Working Time Coronavirus Amendment Regulations 2020 amended the existing working time regulations and have been in place since the 27th of March. Although the government hasn't specifically said that employers can force employees to take leave, it has said that where it has not been reasonably practicable, we don't know what that means, for employees to take annual leave during furlough, those employees can roll over any holiday up to the EU statutory 20-day minimum for up to 2 years. Now, under normal rules, no rollover provision applies to the UK statutory entitlement of 28 days, except in cases like maternity leave or sick leave. However, the government's clearly identified an issue with furlough and annual leave in the sense that businesses may simply not have been in a position, for a number of reasons, to have been able to offer annual leave due to the COVID crisis, hence the introduction of the rollover entitlement. I think once you get past the argument of why should an employee who has been sat at home for 3 months on 80% pay for doing nothing still get holiday, which I get, the rollover provision is actually a really positive thing for you, because it actually allows you to stagger your annual leave obligations and, most importantly, the associated financial liabilities across a total of 3 years if you include this year. Try not to be too down about this provision if you can. I know I've spoken to a few people who aren't overly happy with this, but it is what it is. There's nothing that we can do about it. And remember that you have control over when an employee takes leave. And ultimately, you have control over whether an employee rolls leave over or not. If you don't want them to do it, don't allow them to. Just let them take it this year. In 2 weeks' time, I'm going to be running another webinar, which you're all very welcome to attend, on how you can reduce your employment costs post-furlough to sort of see you through the next phase of this COVID management situation. And if you want to learn how you can use the rollover provision to your advantage in this regard, then make sure you sign up. Couple of final points before we move away from annual leave. Any annual leave taken won't break the period of furlough. They can run concurrently, and annual leave won't affect an ability to claim furlough pay. There's no statutory limits on the amount of holiday that can be taken if the employee requests it. But of course, you can limit it if you want to, perhaps to the amount that the employees will have accrued to the end of the furlough scheme. Also remember that when furlough ends, if you have employees that still can't work because of childcare, dependence leave, etc., then you can look at putting annual leave in place to cover any ongoing period of absence from work. A poll has just popped up. That's for a couple of minutes' time, but if you're happy to share whether you're looking at making redundancies post-furlough, that'd be really interesting. So moving away from annual leave then, and turning to the matter of dismissal during furlough and notice pay, another incredibly vexed issue, because as it stands, employers aren't really sure if they dismiss an employee, how much notice pay they're entitled to. Are they entitled to 100% of their salary, or should they only be paid at 80%? What we know is that if an employee is dismissed during furlough and their notice period runs during the furlough period, you can claim 80% of that notice pay from the government's job retention scheme. In terms of whether that's all you have to pay for your employees or not, this is where the question is a little bit unclear. If we follow the law to its strict letter, then employees who are entitled to statutory minimum notice of termination under their contract should be paid at 100% of their pay if they are dismissed during furlough leave. If an employee, however, is entitled to at least one more week than the statutory minimum notice, then they're only entitled to 80%. Now it's an odd legal provision, and we don't have enough time to get into the weeds of it all today, but if anyone wants to discuss the legalities with me in more detail, or if you have a specific case that you want to discuss, just give me a ring. Additionally, if any of you are running out of activities during the lockdown and you fancy some reading, the relevant law on this point is contained within sections 87 to 90 of the Employment Rights Act. In my view, whilst the law says that in some cases you'll be able to pay an employee 80% of notice pay if they're dismissed during the furlough period, it's likely, highly likely, that a tribunal will strive to find that an employee should have actually been paid 100%. Now, to me, quite simply, this is something that the government have overlooked, and I don't think it's within the spirit of the job retention scheme for employers to effectively penalise employees who've agreed to be furloughed for the good of the business, but who were then subsequently dismissed and who didn't realise that a reduced notice payment was a risk of agreeing to the furlough. It's a tricky one, and again, if you want to discuss a specific case, please let us know, because ultimately each case will turn on its own facts. But to some extent, I suppose you may have a choice as to how much you pay certain employees should they be dismissed during the furlough period. If your employees aren't dismissed during the furlough period and they make it to the end, then, like I say, the current scheme is due to end on the 30th of June. And assuming this remains the case and there's no extension, then you're going to be dumped by the government, unfortunately. And you're going to have to look at taking your employees off furlough leave. In order to do that, there isn't a formal process as yet. You can simply write to an employee telling them that the furlough has ended and they're due back at work. There's no minimum notice requirement. There's no specific form that any letter needs to take. However, there is a template on your client portal that we've prepared for you that you are most welcome and advised to use when you are writing to your employees to let them come back into work. Obviously, the end of the furlough scheme will force employers to bring employees back or to confirm that they're no longer on furlough leave. However, you are allowed to rotate employees on and off furlough leave. So if you want to do that now before the end of June, you can use the same letter that we've prepared to confirm that their furlough is ending and that they're coming back to work for a period of time. If you're thinking that you might need to re-furlough people who you've taken off, just try, if you can, to give your employees the heads up on that point in any letter that you send to them. At the end of the furlough period, it seems highly unlikely, and I think that's probably an understatement actually, that every single business in the UK is going to simply be able to return to operation as normal and have every single furloughed member of staff back at work on their full hours. I think it's going to be the case across the board really that employers are still going to have insufficient work for their employees at the end of furlough, and they'll need to consider laying them off. Layoff obviously is an alternative to redundancy, and it's used ultimately to stave off dismissals on grounds of redundancies by keeping employees on the books for a little bit longer but not having any obligation to provide them with work or pay during this time. In order to lay an employee off post-furlough, you do need a pre-existing contractual right or the employee's agreement, but if you sent one of the later versions of our template letter to your employees who you furloughed, then you will actually have given yourself the right to lay your staff off post-furlough. So have a look at that letter, have a look at the letter that you sent to confirm the furloughing, because it may give you, like I say, the automatic right to simply lay people off immediately at the end of the furlough period. If you don't have a contractual right and you need the employee's agreement, don't worry, we can help you sort of work through the process in order to try and get that. In terms of layoff itself, like I say, it's a way to stave off redundancies and in some respects stave off the inevitable, but it's actually a period of time, a working week, an employee's normal working week in which they get no work at all. They get no work and they get no pay. It's different to short time working, which is, right, you contracted to work 5 days, but we've only got 3 days work. That's similar but different. Layoff, in order for it to be a genuine layoff, has to be no work at all. In order to select for layoff post-furlough, you'll need a fair selection process, and the simple fact that someone has been furloughed will not be a fair justification in itself to select for layoff. You may need to look at pooling individuals who've been furloughed with others who have continued to work, but again, we can help you through that selection process. The layoff provision is a little more fluid than the furlough provision. You can rotate on and off, but there's no minimum or maximum period. So you can lay someone off for 1 week, have them back for 1 week, lay them off again for 1 or 2 weeks. There's far more fluidity in terms of the operations of a layoff provision. The downside, the horrible downside to layoff, however, is that after 4 consecutive weeks of being laid off, or 6 non-consecutive weeks in any 13-week period, an employee can request to be made redundant. Now, obviously, post-furlough, employers, to some extent, are potentially going to be really nervous about having to make redundancies, because it might be the cost of those redundancies which ultimately tip them over the edge when it comes to, cash flow and who knows. So whilst a layoff will provide you with an amount of safety, it's not the perfect solution, and you need to be aware of this right that employees have. If an employee asks you for redundancy pay, it's quite hard to say no unless you can show that there's a genuine chance for work to come back within a reasonable time. So it may be that whilst layoff is something that you want to consider post-furlough, it's not the only thing that you may want to consider. There are a number of other options available to you at the end of furlough, and my next webinar, which like I say is 2 weeks tomorrow actually, because we're on a bank holiday 2 weeks today, is going to look in depth at these options and talk through them with you, the pros and cons of each and the process that you need to follow in order to implement them with your workforce. In terms of a summary of those options though, there are things like the aforementioned use of the holiday rollover, the statutory holiday rollover to your advantage, short time working, which is fewer hours in each working week, redundancies, it may be inevitable eventually, variation to contract, so reduce an employee's pay, reduce an employee's hours, implementation of shift systems. We've had a number of questions on what can I do if an employee refuses to agree to a shift system, even when social distancing can be met. I don't have time to cover this today, but I'll talk about that in a couple of weeks. Another option is company-funded furlough, which I quite like. It's quite exciting. And in effect, this is a way of laying your employees off, but you can avoid the risk of them requesting the redundancy payment by paying them an amount of money for them to basically do no work. Now, it sounds a bit off, but essentially it mirrors what the government is saying. You don't have to pay 80%. You could pay 10%, 20%, 25%, whatever you want. But that could be a preferable course of action than the standard layoff course, which could see your employees be entitled to a full-blown redundancy payment. In addition, a company-funded furlough scheme is controlled by you. You dictate the terms. You can force employees to take leave during any company-funded furlough. There's no 3-week minimum entitlement. You can rotate people on and off. So something to consider, and like I say, something that I'll be talking about in a couple of weeks. The final sort of option, or well, not necessarily the final, but the final option that I've got on my list here is sabbaticals. Now, this is akin to a company-funded furlough scheme, but distinct to a layoff type arrangement, which is more fluid. A sabbatical arrangement sees an employee actually absent from work for a fixed period of time on pre-agreed and reduced terms of employment. There's no risk of redundancy requests, and an employee also has no right to return to the same role post-sabbatical. So again, something a little bit more creative than just your standard layoff, short-time working, redundancy option. So that sort of concludes the main sort of section of the furlough update part of the webinar. I can see that there's a couple of outstanding questions, and I will address those in writing. So look out for that note when it comes through to you. If you're all sort of good for time and you fancy discussing Boris's roadmap, then I'll sort of go through that for the next sort of 10-15 minutes. Again, any questions that you've got, pop them in the Q&A box, and I'll do my best to answer those for you. So 7 o'clock last night, the moment the country was waiting for, hoping Boris would pull through. And it turns out his roadmap was less of a roadmap and more, if you're being diplomatic, perhaps a set of conditional aspirations. There's lots of uncertainty about what he said, and obviously a lack of clarity. During the course of today, the government will be publishing further details about its roadmap. We're expecting a 50-page document sometimes later today. Boris Johnson will be briefing Parliament at about 3:30. At some point as well, we could also expect some guidance on how employers can make their workplaces COVID secure. We'll be keeping obviously a very close eye on all developments, and we will be producing updates and guidance as soon as we can. So again, keep your eye on your inbox and our website for more details. As far as we can, we'll explain what your obligations are in a general sense when it comes to the roadmap provisions, how you can meet with those obligations and what this means for you and your staff. When it comes to employees and returning to work, obviously the update from Boris was that employees should continue to work from home if they can, but anyone who can't work from home, specifically referencing construction and manufacturing industries, should be actively encouraged to return. Now, it is without doubt that that statement perhaps raises more questions than it answers, but in very simple terms, I think that effectively what this means is that if an employer is able to implement safe working practices and adhere to the new guidelines which are being published, then that employer can request that his employees return to work. I say more questions than answers, but sort of following from that very sort of simple kind of interpretation, I think that we can probably go on to say the following. The first point, I think, is that employers are clearly now under a huge responsibility to do two things. One, to make their workplace COVID secure, and two, make it possible for employees who've been unable to work to date because of health and safety issues to be able to return to work. Now, Rob, thanks for this, Charlotte, really useful. I've had to dip in and out. Will you be able to circulate the recording after the webinar, please? Yes, we will. Sorry, I forgot to mention that at the start. The recording will be made available, no problem. In terms of making the workplace COVID secure, I'm not sure how this is going to be possible until employers have had a chance to review the government's guidance on this point, which is due for release hopefully sometime this week. When this is published, I would recommend that you read it. And for those of you who are already health and safety clients, our health and safety advisory team will be on hand to support you with any questions that you have in respect of the points raised. In terms of the sort of second point about making it possible for employees who've been unable to work to date because of health and safety, now this is different to employees who've been unable to work because of a reduction in business or for other more commercial reasons. In terms of those people who've been unable to work because of health and safety, I think the first point to note here is employers ultimately have a fundamental duty to provide their employees with work. That is the basis of the employment contract. Employer provides work, employee does it. If either of those parties fail in that fundamental obligation, then the contract's breached and the other party can sue. Now here, if you took the decision to furlough your employees or close your business because of health and safety concerns, you are now, when it comes to employment obligations, under a very strict, I think, obligation to at least consider whether it's possible for you to bring your employees back, to provide them with work, to fulfill that fundamental contractual obligation. If you can't, then that's fine, but you'll need to be able to demonstrate to your employees that you've thought about the situation properly and you actually have reasons as to why you can't bring them back. If you can, then that's when you're under this obligation, a positive obligation, I think, to start getting employees back in or giving them at least the opportunity to perform work. When it comes to furlough leave, obviously the provisions that sort of underpin that scheme related to an avoidance of redundancies and layoffs due to reduction in work due to coronavirus. Now, if you still can't either open your business or allow all your employees back because you just don't have enough work, fine, no problem. Keep them on furlough, there'll be no issues there. If, however, they were furloughed because you couldn't adhere to social distancing measures, for example, but now actually you can, then you're going to probably be under an obligation to look at bringing those employees back. If you can recommence operations this week and you are able to adhere to the new COVID secure guidance, then obviously it would be the health and safety considerations that will be your primary consideration. I think the message from Boris was clear in the sense that it's sort of health and safety first, economy second. So if you are able to reopen, but you're unable to bring everybody back straight away, then from my perspective, from an employment law perspective, there won't actually be any issues with this. You can quite legitimately, I think, bring a skeleton staff back to start with, and or take a staggered approach to a return to work. Similarly, I don't think there'll be any issues at all if you need to vary hours of work or implement shift patterns to accommodate this phase returning back into work. However, you'll obviously need to consult with your staff about those changes. If you do need to select employees to return on a more staggered basis, or you do need to consult, then you'll need to take advice on how to do this, and that's what we're here for. But I can confirm that any consultation process can take place during the furlough leave period. In terms of sort of other kind of issues that sort of came out, not necessarily from what Boris said yesterday, but which have been in the sort of press this week, the track and trace app, we know that that's on its way. It's understood that individuals who use that app and come into contact with people with suspected or actual COVID will receive an advice to self-isolate. The use of the app won't be mandatory, but you should start thinking potentially about how you will deal with situations that you might be faced with from your employees who use that app. What if they tell you that they've had a text and need to self-isolate? How are you going to accommodate that? What if you don't believe them? What if an employee says that a member of their household has received a text message via the app? You'll have to look at those sort of situations in the round, but I'd say something for you to sort of at least start thinking about. Another point which came out over the weekend is that the government potentially going to be amending the existing flexible working legislation to extend that to a right to work from home. Now, obviously employees can already request to work from home, but what the indication is that employees will actually have a legal statutory right to work from home if they want to, and an employer won't be able to refuse that unless working from home is not possible. We'll keep you updated on sort of how that provision develops if it does, but again, that's something to consider as well, because if it is introduced and your employees can reasonably work from home, you're probably not going to have a defence to any action that you take which prevents them from exercising that right. Does anybody have any sort of specific questions about the roadmap provisions from yesterday? If you do, now's your opportunity. Okay, I'll take that as a no. But if you think of any, then you know where we are. Pick up the phone or drop us an email. Right. So I think that sort of brings this this session to a close. There have been a huge amount of you on this sort of video call, I don't really know what to call them, which we're very, very grateful for. And I would like to thank you very much indeed for your time this morning. Oh, one question. Any employer obligations for staff that have to use public transport? Oh, a good one. Boris has said that employees should avoid using transport. If an employee uses public transport to get into work and that's their only means of travel, then I suppose what we would have to do is look at that individual's personal circumstances and work out actually whether it's reasonable for them to be coming into work. We might need to look at alternatives. So maybe if someone can get a lift or pay for a taxi on a temporary basis, something like that. But I think it's one to sort of consider on the facts of the case as they present themselves. No more questions, are there? No. So yeah, thank you again very, very much for your time. I really hope to see you all. Well, I can't see you, but I hope that you want to see me again in a couple of weeks. Everybody who's on this session today will receive a priority booking opportunity for the next session. And yeah, like I say, hopefully you'll be able to join me then. So I'll hand over to my colleague Louise, but for now, stay safe and keep away from viruses.
Thank you very much, Charlotte, and thank you for everyone who's joined us today. So I just wanted to run through a couple of things, one being the event that's coming up, but also how we're supporting companies at the moment. Specifically, we've been requested for support around the health and safety side. So I know Charlotte mentioned it, but some of the key things that have been mentioned are around risk assessments and documenting your audit trail. Some companies who aren't clients that I've spoken to are really struggling with it and don't know where to start. And then we have had some employment law clients coming to us looking for support. So if you are needing support with the health and safety, whether it's around advice on risk assessments, maybe you need a health and safety management system that you don't have that's up to date, or potentially you need an audit at the premises as things start to return back to normal, just get in touch with us and let me know. Also, we've been supporting clients with senior management training and Q&As, a little bit like this, but having your management team all together at once, being able to speak to the likes of Charlotte and make sure that they're all getting the same message and understand how to move forward. We can do an hour session up to 10 attendees, covering any topic, but I'd imagine it would be around some of the things that we've already spoke about. And then we're also virtually attending strategic board meetings, helping business owners, directors plan how they move forward, coming out of a post-furlough situation. So if you are interested in any of those additional areas of support, just email me, Louise at howarths-uk.com, or call 01 274 864 999. And then finally, the next event is how to flex your workforce and reduce employment costs post-furlough. So that's going to be held by Charlotte again on the Tuesday the 26th at 10 a.m. You will all receive priority booking, so if you're interested, drop me a note and you'll all receive an invite through within the next couple of days. But thank you to everyone who's attended, and thank you to Charlotte. I think she was absolutely fantastic. Take care, stay safe. Thank you.